Hi friends from around the world. Bad faith, that is always entertaining, and it is good to see the bad guys, they are punished by the court. So before talking about the landmark case I want to present you today, there is a little bit of background information necessary in order to understand the bad faith, how it is being treated in Europe. There is no such thing as an exact definition of bad faith. It has evolved over case law from the European Court of Justice, but there's not a legal definition, it's not codified as such in the law. Everything has to be taken into account. You know that already from the European Court of Justice. They say it on repeated occasions. So everything and all the circumstances have to be taken into account in order to determine whether something is bad faith or not. Bad faith, the problem with bad faith is it has something to do with the intention of somebody, a market actor. And in general, well, there is one landmark case you might want to look up at a certain moment. It is always cited when bad faith is being treated in a ruling, and that is the Goldhase case of 2009. Here on the screen is the filing, the ruling. So it is about dishonest practice of trademark use. So to say, it is something which departs from the honest rule of fair competition within the market. That is, so to say, the general rule. And then there are some intentions which need to be addressed by the court. And for example, we have the non-existent intention of use. So if the filer has no intention of use and it files a trademark, then there is something wrong with it. Or the blocking of a trademark in order so a third party cannot file for it. That would be also something. Or if there is no commercial logic underpinning the filing. So these are the three, so to say, cases which have been identified so far by the European Court of Justice, so far until the monopoly case. So still, there are monopoly case is the one I want to tell you, but still some more information on the European law with regard to bad faith. You may have a look in episode 10 of the Trademark series of the videos here on this YouTube channel, where you can more about bad faith, but some words more on bad faith in Europe. So in the examination phase and opposition phase, which lead then to the registration of a trademark, we have no, so to say, institutional way to look at bad faith, because it is not an examination ground and it is not a opposition ground. But it is an invalidity ground, but invalidity comes only after registration, you know that. So this is how it works in Europe. And now let's come to the case, monopoly. You may have played this game on the table game, so to say, with fake money and buying properties on streets and famous streets all over the world, and you know, you're the highest one and the lowest one, and you sell them, and you make a hotel on it, and you have to pay if you go on it, etc. So that is monopoly. Monopoly has been invented, so to say, by Hasbro. Hasbro is an American company with toys, very big one, a big company. So Hasbro has the trademark monopoly since 1998. So in 1998, Hasbro filed and registered and obtained the registry of the mark monopoly for goods in classes 9, 25 and 28. That was in 1998, right? In 2008, the same trademark was filed and obtained the registry for class 41. And in 2010, again, the same trademark, this time for class 16. Now, in 2011, there was the same trademark, monopoly, the word mark monopoly, was again being filed at EU IPO, and this time for a variety of goods and services, all of them what has been filed before already, so 98 and 2009 and 2010, plus other goods and other services, but always in the same classes. That would be 9, 16, 26 and 41. So this is the situation with Hasbro trademarks, right? So in 2015, so once the registration of the 2011 trademark has been filed and obtained the registry, a third party filed a request for invalidity against the last trademark of 2011, and it was claimed that the trademark has been obtained or has been filed and the registry has been obtained in bad faith. And what has been, so to say, alleged as a reason of bad faith was the so-called evergreening of the trademark. What is an evergreening of trademark? So you know already that the proof of use, what proof of use is. You are a specialist in IP, so I don't need much to go into it. 5 years before filing of the invalidity request in this case, so you have to prove the use of the mark. Or in opposition cases, if you want to make an opposition, so the trademark owner, it can defend itself by saying you prove your opposition mark, you have to prove the use because it is older than 5 years before the filing of the opposition. So the general rule is you need to use your trademark, and it is clear. So we want to have a trademark registry which is close to the market and which is not some, absurd, abstract register of things that people are crazy about. No, it is about the use on the market, right? Now, this is about the proof of use. So the alleged, the comment of the third party was that the 2011 filing, so the last filing, the more complete filing, has at its ultimate goal to circumvent the proof of use rule. Meaning that if they want to make an opposition with the 2011 filing or registry, then they could do it without having to prove the use of the mark because they are still in the grace period. So 2011, 2016. So until 2016, they can make their oppositions against other marks without the necessity to prove the use of the earlier mark. So that is the scene setting, right? That has been done by the cancellation division with EU IPO in 2015, as I said, and the cancellation division, they rejected that claim, invalidity claim. So it went to the boards of appeal from the third party. So the boards of appeal, they took a different approach and they admitted the invalidity request and rejected the Hasbro monopoly trademark of 2011. Now, the Hasbro went to the General Court. General Court is the first instance court, you know this, in Luxembourg against decisions of the Board of Appeal of EU IPO. Now, here it comes, the General Court, they declared first that repeat filing is possible. Repeat filing is nothing, there's nothing against a repeat filing. So you can repeat a filing as often as you want. What is a difference is when repeat filing and evergreening, so to say, is being done in order to obtain certain advantages which have nothing to do with fair competition or, original use of the trademark for what is it is allowed to be used, or it is it has been created to be used within the trademark law. And during the proceedings, there was a certain moment that Hasbro recognized that they would have, through this new filing in 2011, they would have the possibility to lessen the burden of proof of use. So they would not have the necessity to document all the use of the trademark in order to have to prove the proof of use once it is raised by the other party of the case, whatever it is. So what they knew is that the new filing and the refiling of the same trademark with the same goods and services would have this effect, and there's no other allegation or other logic, economic logic, which has been advanced by Hasbro and which would justify in an economic logical way that they need to file this broad trademark in 2011, so refile this broad trademark in 2011. So these circumstances, factual circumstances, objective circumstances, which have been clarified by the Boards of Appeal and confirmed by the General Court, was that there was in effect an intention from Hasbro to circumvent the proof of use requirement when it comes up in a future, case. Meaning that the General Court said, well, that is bad faith. So we have the three cases we had already, and we have a fourth case now, which would be the evergreening in an intention, so to say, to circumvent the proof of use requirement. What does that mean for you as a counsel or for the company you're counseling in your practice as a lawyer? Well, the fact is that we have now a precedent with regard to the evergreen rule. I don't know whether evergreening is a common practice, as the Hasbro said in the Boards of Appeal proceedings and repeated in the General Court proceedings. It is a general approach, everybody does it. So why would you pick out on me? But the General Court said, well, if it is a general practice or not, I don't care. The general practice may be wrong. And in that case, if it is general practice, that general practice would be wrong. Now, if there are a lot of these evergreening, so you would think that a lot of future cases, invalidity cases, may pop up on the precedent we have now from the General Court. I would doubt that because I haven't seen from April 2021, I haven't seen so many cases coming up with bad faith. So bad faith is, I would say, rather rare and exceptional ground for invalidity which has been raised. So it is not very current here. I was in China before, and the bad faith filing was one of the biggest concern Europe had with regard to China and trademark law. though this is not really the case here, and I haven't seen so much increase in bad faith filing. But for what is the counseling of your client, well, you can rely on the older marks, and you can and you should counsel your client with documenting on the use of the earlier marks. Even when you make a kind of evergreening, you have an economic logic to do so. That is an important issue. And if you are kicked out, well, you put the opposition cases on the older cases and on the new cases. So one or the other against the new case, there can be the circumventing the bad faith. Against the old case, there can be you don't have the proof of use. That is possible. But if the company you're counseling are aware of that possibility and you make the counseling a kind of preventing future problems, then they know from now what they have to do and what are the risks they are failing. Thank you for being with me. Thank you for your time, and a like would be a good thing for the YouTubers. Thank you.